is my great pleasure to welcome all of you to the online seminar organized by the Center for Comparative and Transnational Law at the Faculty of Law of the Chinese University of Hong Kong. My name is Hao Zhang. I'm an assistant professor here at the CUHK Law faculty. I will be the moderator for this seminar. Today's seminar is the first event organized by the CCTL's newly constituted cluster on environmental, energy, and climate law, and we plan to organize such seminars on a regular basis. The speaker for tonight's seminar is Benoit Mayer, who is an assistant professor at the CUHK Law faculty. His expertise lies in the international law on climate change. He's the author of a textbook on the international law on climate change published by the Cambridge University Press, and is currently writing a monograph on the obligations of states under international law with regard to the mitigation of climate change. Professor Mayer is also a member of the roster of experts under the United Nations Framework Convention on Climate Change. The presentation that he's going to deliver is titled Climate Change Mitigation, the Role of Environmental Impact Assessment, which is based on the paper published in International and Comparative Law Quarterly. For that article, he received the journal's Young Scholar Award. Please note that this seminar is recorded. The recording will be made available online after this seminar. Professor Mayer will speak for about 1 hour. During his talk, please feel free to send me your questions through the chat function. I will be able to collect all the questions which will be answered at the end of the talk. Professor Mayer, the floor is yours.
Thank you very much. Do let me know if you do not see the screen or if you don't listen to me, otherwise I assume everything works well, which is not always the case when I use electronic things. So thanks a lot, Hao, for the very kind introduction. And thanks to all of you, 104, to join us from different places. Many of you in Hong Kong, but some of you in other places or countries across the world. So warm welcome to online CUHK Law. As Professor Zhang has mentioned, the work that I'm going to present today is already published, but I will add is still a work in progress. And what I'm going to present is not exactly the same actually as the publication. That's a very lively topic that is evolving quickly. There have been new cases actually since I published the piece. So that's also a thing, as Professor Zhang said, you can ask questions or make comments, and that could be useful actually for the next publications, including the book that I'm writing at the moment on state obligations on climate change mitigation. So this paper is about the obligations of states to conduct environmental impact assessments as a tool for climate change mitigation under public international law, under customary international law. But I suppose that many of you are more interested in the comparative law perspective that will be integrated in this research. When we try to identify customary international law, we have to understand state practice. And therefore, a lot of this paper is actually a comparative paper where I look at what different states do with regard to climate change mitigation, and in particular in relation to environmental impact assessments. So let me start with the background. I think we all of those who are attending the seminar understand that climate change is happening, that you probably do all believe in climate change. And you do all understand that international cooperation is necessary to address climate change, to mitigate climate change, to reduce greenhouse gas emissions. If there are about 197 countries in the world, all of them contribute somehow to a different proportion to global greenhouse gas emissions. And therefore, there needs to be some international cooperation to address climate change. However, each individual state is interested in relying on others to do the hard work. And that's why we have a collective action problem where each state is trying to do nothing while waiting for other states to do something to reduce global greenhouse gas emissions. And of course, if every country does the same, then we don't address climate change. So to address this collective action problem, which is really at the core of the issue of climate change, we need to have some rules, some obligations applicable to states to compel states to reduce their greenhouse gas emissions and to invest in climate change mitigation. Those obligations can arise from treaties, and for the last quarter of a century, even more, states have been trying very hard to, working very hard on trying to adopt and implement treaties that contain ambitious obligations on climate change mitigation. But frankly, that has not been a very clear success. The 1992 UN Framework Convention on Climate Change is a sort of an umbrella. It contains only some principles, some vague obligations, but not really anything useful, or not really anything that has far-reaching implications. The Kyoto Protocol was applicable to developed countries, except for the US and Canada, so to basically mostly European countries, for a first commitment period from 2008 to 2012. And it has led to probably to some reduction in greenhouse gas emissions in those countries, but it has been quite short-lived and quite localized in a sense, only limited to countries that represent about 12% of global greenhouse gas emissions. There is an attempt to extend the Kyoto Protocol to a second commitment period from 2013 to 2020 under the Doha Amendment to the Kyoto Protocol, but the Doha Amendment has not entered into force yet. So at the moment, states do not have any formal obligation under the Kyoto Protocol. And then we have the Paris Agreement adopted in 2015, which creates vague obligation for states to pursue measures towards trying to achieve the objective contained in some NDCs, nationally determined contributions, that states write themselves and communicate to other states. This applies in principle to all states, but the NDCs being determined by states themselves are not very ambitious. And states have repeatedly recognized that current commitments under the Paris Agreement are not sufficient to achieve the objective of the Paris Agreement of holding the increase in temperature below or well below 2 degrees. At the moment, we are heading towards a warming of 4 degrees by the end of the century. So far more than the objective of states. So in a nutshell, treaties do define specific obligations, but those obligations are extremely undemanding. They are insufficient. And that's because of the way negotiations work. Negotiations always lead to an agreement based on the lowest common denominator, based on what all states can agree with. And you, of course, have some states who are a bit more reluctant to agree on ambitious obligations. So treaties are useful, but they're not sufficient. So in my research, I also look at other sources of international law that may or do create obligations on climate change mitigation. I look in particular at unilateral declarations, for instance, at the legal force of declarations made by states. But I also look at custom. Now, so I'm not sure, some of you have a background in international law, some of you don't. So for those who only know domestic law, when you hear the word custom, if you don't think about customs, about importation of goods and so on, if you think of customary law, you probably think of history. In Hong Kong, we do have some customary law, but that's quite limited in scope. In international law, custom is much more important. And I think a majority of the decisions of the International Court of Justice, for instance, apply customary international law. treaties are compulsory under international law because of a customary rule that says that treaties are compulsory. So custom is much more important in international law. Now, there are obligations under customary international law on climate change mitigation, but those obligations are often viewed as extremely vague, perhaps more demanding than treaties, but very difficult to interpret and very difficult to apply in any given case. I think there's almost a general agreement among scholars, with some exceptions, that there is a general obligation of all states to exercise due diligence. A state should try to prevent activities taking place on its territory which may have an adverse impact on the territories or on the rights of other states. You cannot prepare a terrorist attack against state B on the territory of state A. State A has an obligation to prevent you from doing that. That has been recognized in the case of Corfu Channel in 1949, where the courts, the International Court of Justice, found that Albania had an obligation to supervise activities on its territory, including the laying of mines that may impact the rights of other states. In that case, that led to an explosion that killed some soldiers from the UK. General obligation on due diligence probably applies to climate change, but what it means is very difficult to determine. There has been one major case in domestic law, applying international law, by the Supreme Court of the Netherlands in the case of Ogenda against the Netherlands in 2019. In that decision, the court basically found that the state had an obligation to mitigate climate change, to decrease greenhouse gas emissions under human rights law, which the court interpreted as equivalent to customary international law, and that's actually a problem in itself. And then the court then interpreted customary international law, including this general obligation of due diligence. And the court said that under customary international law, the state had an obligation to decrease greenhouse gas emissions in its territory by 25% by 2020 as compared to 1990. So that has been, I mean, many people have spoken about this case, about this decision, but the logic is quite difficult to follow. There is quite a big logical leap between recognizing a general obligation of due diligence and saying that the state has an obligation to decrease its greenhouse gas emissions by 25% by 2020 compared with 1990. It's quite difficult to arrive at this level of specificity based on interpretation of customary international law. So I think there is some question to ask about the validity of the reasoning of the court in this decision. But there might be other ways to try to interpret customary international law, and that's really where I come to this paper. There might be some corollary obligations to the general obligation of due diligence. And in this paper, I'm looking particularly at the obligation to conduct an environmental impact assessment as a corollary of the general obligation of due diligence. And this is building on some case law that recognizes that sometimes the general obligation of due diligence may imply an obligation to conduct an environmental impact assessment. But let me first explain what is an environmental impact assessment, or EIA, just to be sure we are all on the same page. An EIA is a procedural obligation, a procedure basically to inform decision makers about the potential environmental impacts of proposed activities. So for instance, before authorizing the extension of the Hong Kong airport, the Hong Kong government, the Hong Kong Environmental Protection Department, required the Hong Kong Airport Authority to develop a scientific study and to go through some phases of public consultation in order to better understand the impact of the project and the environment. An EIA is never about preventing a project. It's just about making sure that all the information is available to the decision maker, to the government, when the government allows a project. So we want to be sure that the government really understands the consequences of a project before authorizing this project. Typically, an EIA will include at least two elements: a scientific study, a scientific assessment. You have some experts looking at the impact of reclamation on marine life, the impact of planes, of having more planes, on noise, and so on different environmental concerns. And then you have a phase of public consultation where people can express their views on the project based usually on, usually they can look at the scientific study, so they have the information. And at the end of this process, you have then a decision by the government whether to authorize the project or not, or in most cases, to authorize the project, but with some conditions aimed at reducing the impact of the project. So it is key in an EIA that you look at the alternatives to the project. So perhaps we can do without planes, we can do with more trains instead, or at the alterations of the project. So perhaps we can design the airport slightly differently so that perhaps planes have less taxiing, or they will not be landing close to a city, so it will not have too much impact in terms of noise and so on. So it can be quite technical, but really the aim is to ensure that we have done all we could to reduce environmental impacts. EIA is now implemented in almost every country, and I'm saying almost because I cannot prove that every country has it, but pretty much every country I'm aware of has a mandatory EIA, or at least a very consistent practice of implementing EIA for any project likely to have a significant environmental impact. EIA has also been recognized as a customary international law obligation, as I hinted to earlier, in a transboundary context. So that's, for instance, the case of pulp mills between Argentina and Uruguay before the International Court of Justice in 2010. In that case, the International Court of Justice found that every state has a customary international law obligation to prevent transboundary environmental harm. So an obligation to exercise due diligence, to take appropriate measures to try to prevent transboundary environmental harm. That's also something that is sometimes called a no harm obligation, or an obligation of prevention. All of those pretty much refer to the same idea, to an obligation of the state to take appropriate measures to try to prevent transboundary environmental harm. And the court also interpreted this obligation of due diligence as implying an obligation to carry out an environmental impact assessment before authorizing a project when this project creates a risk of causing transboundary environmental harm. So EIA appears in this judgment as one of the appropriate measures that a state must carry out as part of its due diligence obligation. But the court also looked at empirical evidence of the existence of a customary rule, including state practice and acceptation as law. I'm going to come back to that. Now, there is a question on whether this decision applies to climate change. And I don't think this is obvious. Climate change is not a typical case of transboundary environmental harm. It is quite different from the case in pulp mills. In pulp mills, you had one state building a small factory along a river, causing pollution of the river that would affect the other states. So you had state A causing pollution to state B, causing harm to state B. That's not really the same for climate change. climate change is caused by 197-ish countries, and it's harming 197-ish countries. You cannot really pinpoint one project causing harm directly. It is more a case of a cumulative harm, and of the harm caused not directly to a particular state, but caused to the global to the global environment. So instead of a transboundary environmental harm, stricto sensu, climate change is more of a global environmental harm. And therefore, there are some questions as to whether the same reasoning could apply in transboundary environmental harm cases and in global environmental harm cases like climate change. The due diligence obligation surely applies to climate change. At least I have written that in other papers. I'm not going to make the arguments here. But it's a bit more questionable as to whether the EIA obligation also applies in relation to climate change. So in this paper, I had to come up with some terminology. Instead of speaking about the use of EIA as a tool for climate change mitigation all the time, I've decided to use the concept of climate assessment. I first actually in the draft had the concept of climate impact assessment, but CIA as an acronym could be misleading. So I prefer to speak about climate assessment, even though CA could also stand for Court of Appeal, so it could also be misleading. In any case, so climate assessment is, the way I use it is as a shortcut for the use of EIA procedures as a tool for climate change mitigation. So that means the same as an EIA, scientific study looking at the potential greenhouse gas emissions that a project will cause, and also at the possible alternatives or alteration of the project, and possibly some kind of public participation process where individuals interested in the project may give their views. And all of this has to take place before a decision is made on whether or not to allow a project to be implemented. In practice, climate assessment is a component of EIA. It is not a separate procedure. Now, what I have found in this research is that many countries have climate assessment procedures, but they don't even have a concept for it, and they don't have a systematic approach of this procedure. So they have not really identified the key issues that appear when you try to implement EIA as a tool for climate change mitigation, and they have not really thought systematically about how to address those issues. So the main argument in this paper is a public international law argument about whether climate assessment is or is becoming an obligation under customary international law. And spoiler alert, I'm going to argue that it is probably not an obligation under customary international law yet, but very close to it. And I wrote this paper a year and a half ago. I think if I wrote it today, I would have to consider very carefully whether I will change the position. I mean, this is evolving quickly, and I will bet that in a few years, the rule will be better established than it is today. So how do we address this question? How do we determine whether climate assessment is an obligation under customary international law? There are two different methods under international law to identify a custom. The classical method is inductive, which means that you look at empirical facts. You look at what is happening on the ground to try to generalize a conclusion. A custom is by definition a general practice of states accepted as law. So in the inductive method, we look at whether there is a general practice of states, and we look at whether this practice is accepted as law. And I will come back to it. That will be the first part of the substantive of the paper, the first substantive part of the paper. But then there is another method, which is also quite important in practice. And which has been instrumental in the case of pulp mills, for instance, which I mentioned before, where the ICJ found an obligation to conduct an EIA in a transboundary context. The other method is the deductive, sometimes called modern method of the identification of customary international law. And this method is basically starts with a general principle and infers a more specific rule. So we would start, for instance, from the obligation of due diligence, and we will infer that if we have this general obligation of due diligence, we must have that more specific obligation, for instance, in my case, to conduct a climate assessment. The obligation of due diligence has repeatedly been interpreted by international courts and tribunals as an obligation for a state to take all necessary or all appropriate measures. So here we have to ask ourselves what will be all necessary measures against climate change or all appropriate measures against climate change. And there will be an argument to say that if a state is taking all necessary or appropriate measures against climate change, then the state should conduct a climate assessment. So we will have an inference. We will start from a general principle and we will infer a more specific rule of conducting a climate assessment. Now, whether this method works in practice in the case of climate assessment really depends on whether we believe that due diligence requires states to take all necessary or all appropriate measures. Logically, it should be all necessary measures because you only look at what is logically necessarily implied by the first rule. So we will look at all the necessary consequences of the primary rule. States have to exercise due diligence that requires necessarily a climate assessment. This argument will be difficult to make because there are alternatives to climate assessment. A state could mitigate climate change without conducting a climate assessment. So the appropriate measures test is much easier to meet, but it's logically a bit more problematic because there is no reason why you would impose on the state one particular appropriate measure as opposed to another alternative appropriate measure. It could be that instead of requiring climate assessment, a state will prevent any development on its territory, and that would be perhaps an appropriate measure as far as climate change mitigation is concerned. However, international courts and tribunals have very often referred to appropriate measures. There is a very difficult question in international law as to whether the deductive method is sufficient on its own to identify customary rules. And so there are different views on that. My understanding is that a deduction has to be supported by at least some elements, some empirical elements under the inductive method. So the inductive method could be self-sufficient to demonstrate the existence of a rule. The deductive method is probably not entirely sufficient. And that's a very conservative approach, but that's, I think, the dominant one in international adjudication. The deductive method could, however, help to fill some small gap or dot in on the conclusions based on the inductive method. But so in the following, I will look at both methods or approaches to the identification of customary international law, and I will try to identify whether there is an obligation of states to conduct a climate assessment on the customary international law, either from the inductive approach or from the deductive approach. So I will start with the inductive approach, which is very empirical based, and therefore I think is part of the paper that is largely comparative, because I have to look at state practice to know whether there is a general practice of states. So the first element, again, is the existence of general practice of states, and the second element will be the acceptation of this general practice as law. And I will come back to what it means later. This first test will not entirely succeed, and then I will have to turn to the deductive approach, and I will show that it in itself, it might not be sufficient either. And therefore, the conclusion of the paper will be that we have probably an emerging customary rule, but not yet one which is firmly established. So under the inductive approach, we first have to look at whether there is a general practice of states. And so the paper has a lot of references. I'm not going to go through all of them. I just highlight here 3 typical examples, but there are much more. There are some countries or jurisdictions that have rules or guidelines that interpret existing laws on EIA as requiring the implementation of EIA as a tool for climate change mitigation. So a clear example of this is the European Union. The EU has a directive on environmental impact assessment and a separate directive on strategic environmental assessment, which is why you have directives. Those directives have been amended in 2013, and states have to implement the amendment by 2017, so as to include the impact of projects on greenhouse gas emissions within the scope of EIA. So every EU member state since 2017 has to have a compulsory climate assessment procedure. The EU has adopted some guidance documents to try to tell states how to do. But those guidance documents actually are not very helpful. They're very vague and very short. Far more interesting documents were adopted by the Council for Environmental Quality in the White House in the US, interpreting the National Environmental Protection Act under US federal law as requiring the conduct of climate assessment. Those guidance documents in the US have been withdrawn by the current administration, but they continue to be implemented by courts in practice. But those really are just examples of rules and guidelines, and I could go on forever speaking about other examples. There are some other jurisdictions where the government or the parliament have not acted, have not added any requirement on climate assessment, but courts have taken the lead. And actually the case in the EU or in the US before any documents were adopted. But if you look at South Africa, in 2017, they had a case decided by the High Court in Johannesburg about a coal plant or a coal mine, I'm not sure at the moment. So basically an EIA procedure that had led to a decision approving a project. I think it is a coal plant, a power plant. The government had approved the project, and then some NGO brought the case to court saying that the EIA study had not included an assessment of the impact of the project on climate change, and therefore the EIA was incomplete and invalid. The court accepted the argument, and therefore the approval of the project was cancelled. The project proponent, the power plant company, had to apply again, and this time document the impact of the power plant on greenhouse gas emissions. Again, you have many other examples, some of them under EU law, including in the UK, at the time when the UK was under EU law, or in Austria regarding airports projects, or in Australia regarding coal mines, and in other jurisdictions as well. So you have many different cases. And then there are some jurisdictions where you have a practice without any legal basis, without any statutory basis, and without any court cases. And I think the most prominent example is China, where one study looked at environmental impact assessment reports produced in China and found that about 1/5 of EIA reports included some consideration for greenhouse gas emissions. So that shows a relatively consistent practice. Only 1/5, but many projects that have to go through an EIA do not involve any greenhouse gas emissions, so they will not require a climate assessment. So I think that this actually is evidence of a relatively consistent practice, which kind of oddly is not based on any mention of greenhouse gas emissions in the 2001 EIA law or the 2009, I believe, law regulation on EIA planning projects. And there are two vague references in some technical documents to greenhouse gas emissions in the context of the implementation of the EIA law, but there's really no general rule or guideline. This is more an organic practice implemented by the local environmental authorities. However, there are also some exceptions. I'm not trying to, I'm not claiming that every jurisdiction in the world has a practice of conducting climate assessment. There are some exceptions. There are some exceptions where there is simply no debate or no decision. And that's, I think, is consistent with an ongoing trend where you have some latecomers. India, the notification on EIA of 2006 does not mention greenhouse gas emissions. In practice, EIA reports do not mention greenhouse gas emissions. There's never been a case until in 2017, the case of Pandey before National Green Tribunal, which has not been decided yet. Pandey argues that the government, among other things, has an obligation to review the 2006 notification on EIA and to include a compulsory climate assessment procedure. Another example of no debate is Hong Kong. The 1997 EIA ordinance in Hong Kong has never been modified. It is one of the oldest unmodified EIA laws in the world, which is not a very prestigious title. It's quite out of date. And therefore, the EIA ordinance does not contain any references to greenhouse gas emissions. I mentioned before the extension of the Hong Kong airport. A study on greenhouse gas emissions was conducted by the Hong Kong Airport Authority, but it was not publicized. The summary was made available, but not the entire study. And it was not added in the EIA report. So the EIA procedure and the consultations and the decision to which it led did not consider the greenhouse gas emissions of the airport and did not consider any possible ways to reduce those greenhouse gas emissions, including by minor alterations of the project. There are some other jurisdictions where there has been a debate and a decision of the administration and the government to exclude climate change mitigation from the scope of environmental impact assessments. I'm aware of two examples, and there could be a third one in Queensland, in Australia, but I'm not sure if the case law is very clear. The two examples that are really clear are New Zealand and Kazakhstan. Both of them are based on statutes that explicitly exclude any consideration for greenhouse gas emissions from the scope of EIA reports. And both of them, interestingly, both of those exclusions were based on the same reasoning, and both of them were about 15, 20 years ago. In both cases, New Zealand and Kazakhstan wanted to implement a cap and trade mechanism. They will have a maximum amount of greenhouse gas emissions. Polluters will have to buy emission allowances. There will be a cap and a trading system. And that way, the government will be sure that the emissions within the jurisdictions will be limited to a particular quantity. And what led to the exclusion of climate assessment was the idea that it would be redundant to have a cap and trade mechanism and a climate assessment. The reasoning was, if we have a cap and trade mechanism, we know that next year we will have X amount of tons of carbon dioxide emitted. The EIA, the climate assessment, will just kind of repeat what companies already have to comply with. There are two reasons why I believe this reasoning is invalid. One is that a cap and trade mechanism is based on reviewable caps. No cap and trade mechanism fixes a cap forever. If you look at the EU cap and trade mechanism, the EU emission trading scheme, there is actually a lot of intervention by the EU Commission to try to regulate the amount of allowances available on the market. So if you reduce the demand for allowances, you make it possible for the regulator to reduce the cap, and there can be some reduction in greenhouse gas emissions. That's a technical point. That's what we on the waterbed effect. The other reason why I believe the reasoning of New Zealand and Kazakhstan is invalid is because cap and trade mechanisms are quite limited. In the EU, only about half of the emissions of greenhouse gases happening within the territory of the EU, within the implementation period of the ETS, are covered by the ETS. So a lot of emissions are not covered by the ETS. Transportation emissions are never covered because it would be too difficult to ask you to buy an emission allowance before driving your car. A cap and trade mechanism is only concerned with big stationary emissions in most cases. So most of the time, actually, a cap and trade mechanism will not regulate the type of emissions that a climate assessment will regulate. So I believe that those two states were basically misled into excluding climate change mitigation from the scope of the EIA processes. But that's really a parenthesis. The main point here is that generally, we do have a general practice of states. It might not really be obvious from the few examples I have given, but if you look at the paper, there are more examples. I guess I look at about several dozens of jurisdictions. There seems to be a general practice, not a uniform practice. There are some exceptions, but that's not what you need for a customary obligation. You need a general practice with possibly some exceptions. And I think we do have a general practice with some exceptions. So the first element to identify a customary obligation of states to conduct a climate assessment, I believe, is met. We do have a general practice of states. What is more difficult is, however, the acceptation of this practice as law. So that's the second element of the inductive method to the identification of a customary rule. States have to accept the practice as law. And this is why a custom is not the same as just a habit. You know, you do a lot of things by habit. This is not necessarily a custom. There is a habit that when a state nominates a new ambassador, the ambassador will invite his colleagues to a party. This is not a customary obligation. This is just a habit. A custom has to be based not just on a general practice, but on a practice which states do out of a belief that this is an obligation. So this acceptation is a subjective criteria. You have to look at the mental element, at what states believe is the reason why they're doing something. Of course, this is nonsense because states do not believe. I have never met a state. States are fictions. They are made of individuals, of many of them, and those individuals have sometimes different beliefs. So if you want to know what the UK believes, you don't really know who to ask. Are you going to ask the Queen or the Prime Minister or the Parliament? And sometimes those people change. So you may have, it may be very difficult to identify this subjective element. So there are some difficulties, of course, conceptual difficulties with this element of acceptation as law. In practice, when we look at the acceptation as law, one method that could be relevant here will be actually to look back at state practice. There are instances where international courts and tribunals have found that state practice could in itself be evidence of acceptation as law. There are some examples, some instances where you do something and the only possible reason you do it is because you believe you have an obligation to do it. If this is against your personal interest to do something and you still do it, it must be because you believe you have an obligation. So that's the reasoning here. And it could apply perhaps to climate assessment. If you have many states implementing climate assessment, that seems to be not in their interest. One state is not really interested in reducing its own greenhouse gas emissions because those emissions have a global impact, not really an impact on the state itself. So if a state thinks very selfishly, and sometimes they do, the state will think, okay, I don't really care about those greenhouse gas emissions, they will affect other countries, so I will not conduct a climate assessment. Now, if states do conduct a climate assessment, the reasoning goes, it must be because they believe they have an obligation. And I kind of agree with this argument, except that I'm not sure what the obligation states believe they have is. It might be that the obligation states believe they have is not an obligation to conduct a climate assessment, but is an obligation to exercise due diligence. It might be that the obligation is broader and it's not specifically the obligation to conduct a climate assessment. It might be, and I think that's actually the case, that states believe that they have an obligation to take some measures to try to mitigate climate change, and therefore they conduct climate assessment. But in my interpretation, then you don't have a specific acceptation of the obligation to conduct a climate assessment. So there is at least some questions to ask as to whether this reasoning really works. The other elements that could be looked at if you want to find whether there is an acceptation of practice as law is treaties. If you look at the law of the sea, states generally agree that, and courts generally agree that states have an obligation not to cause pollution to the marine environment under customary international law. And one of the reasons would be that you have the UN Conventional Law of the Sea of 1982, which says that states have an obligation to prevent pollution to the marine environment. And the treaty is written in such a broad way, it seems to be a codification of a pre-existing obligation. It is a declaratory treaty. It is not creating a new obligation, it is recognizing a pre-existing obligation. And that means that the US, which is not a party to the UN Conventional Law of the Seas, is bound by the rule of customary international law, which is codified and expressed in the UN Conventional Law of the Sea. Now, if we try to develop this argument on climate assessment, the issue that we don't have any treaties recognizing clearly an obligation of states to conduct climate assessment. If you look at the UN Framework Convention on Climate Change, the 1992 Umbrella Convention, Article 4, Paragraph 2 contains provisions, Paragraph 1, sorry, contains a provision saying that parties must take climate change considerations into account to the extent feasible in their relevant policies and actions. But this is not really specifically about climate assessment, about the use of EIA in particular. And actually the sentence continues saying that states should have EIA as a way to anticipate the impacts of climate change, which is not the same as what we're talking about. It is about adapting to the impacts of climate change. It's not about reducing greenhouse gas emissions. So the same sentence mentioned EIAs, but not in relation to climate change mitigation. And therefore, it is very difficult to interpret this provision as suggesting a customary obligation. Another reason why I don't think this is a codification of customary international law is that the sentence is about parties and not about states. So it doesn't seem to be a recognition of a pre-existing obligation. It seems to be the creation of a new obligation. So this obligation in any case would only apply to the parties to the UNFCCC and not under customary international law. The case of pulp mills, which I mentioned before, the ICJ relied heavily and problematically on a regional convention, the ESPO Convention, on environmental impact assessment in a transboundary context. And the ICJ really relied on this convention as evidence of an obligation of states to conduct an EIA in a transboundary context. Now, the same could not, I mean, first there is a difficulty of using this convention as evidence of customary international law because it is a regional convention adopted under the UN Economic Commission for Europe and ratified mostly by countries from the global north, European countries, Canada, and Russia, and some Asian, North Asian countries. But it remains relatively limited, and it is not phrased as the recognition of pre-existing obligations. So there is some difficulty even in following the reasoning of the ICJ in pulp mills. But this reasoning in any case could not easily be replicated in relation to climate change because the ESPO Convention only applies in a transboundary context. And actually the definition of transboundary harm in the convention is explicitly exclusive of harm of a global nature, exclusively of the global nature. And if this does not exclude greenhouse gas emission, it is not clear what it could exclude. Greenhouse gas emissions is the example, the most obvious example of an impact exclusively of a global nature. CO2 emissions, unless they're really, really big, normally do not have a local impact. They only have a global impact. So the ESPO Convention does not cover climate assessment and therefore is not evidence of acceptation as law of the obligation to conduct a climate assessment. There are, however, some discussions happening at the moment under the ESPO Convention, under its Kiev Protocol on strategic environmental assessment, and also under the UN Economic Commission for Europe. Some informal discussions among states as to whether and how far EIA could be a relevant tool for climate change mitigation and whether it should be formally recognized. So there could be some evolution here in the years to come. At the moment, however, there is no clear consensus, even among those countries, which usually are kind of leading in terms of development of environmental law. So the conclusion on this second element of the inductive approach is that we don't have an acceptation or acceptance as law. So we miss one of the two elements to demonstrate the existence of a customary obligation to conduct a climate assessment under customary international law using the inductive approach. We have a general practice of states, but we don't have a clear acceptation of this practice as law. So basically, we may have an emerging obligation under customary international law, but there is no evidence under this first approach of the existence of a customary obligation. Sorry. Then let me turn to the second approach, perhaps to be more conclusive. Perhaps the deductive approach will help to fill the gap in the inductive approach. So here we have to look at whether climate assessment is a useful tool for climate change mitigation, whether it is an appropriate measure that states have to implement to comply with their due diligence obligation under customary international law. So you remember that states have to exercise due diligence. That means that they have to take all necessary or appropriate measures. We're not sure if it's necessary or appropriate. And so here we are going to look at whether climate assessment has to be understood as a necessary or appropriate measure that states have to implement on climate change mitigation under their due diligence obligation. So EIA is largely viewed as generally an appropriate tool for environmental protection. And this is why pretty much every state has an EIA legislation. And this is also why the ICJ could recognize EIA as an obligation under customary international law in a transboundary context. So apparently, we should start with the assumption that climate assessment, which is a form of EIA, is also an appropriate and perhaps necessary tool for climate change mitigation. But there are some objections. So I think the first point here is that the burden of proof is basically on those arguing that there is no obligation under customary international law. And then we have to look at the objections. Why basically those objections would be arguing that while EIA is an appropriate tool to protect the environment generally, it is not appropriate in the context of climate change mitigation because possibly of some specificities of climate change as opposed to other environmental issues. So the objections would basically be something of the sort of EIA is usually a very useful tool to protect the environment, but climate change is a bit different, and therefore EIA is not really useful to mitigate climate change. In my review of judicial decisions, debates in a number of countries, I have come up with three main concerns or objections to the appropriateness or usefulness of climate assessment as a tool for climate change mitigation. The first concern is that every single project taken individually contributes almost nothing to climate change. And therefore, there will be a difficulty, or it will be virtually impossible to have an objective basis to determine what projects have to go through a climate assessment and what projects should not go through a climate assessment. An EIA or a climate assessment only applies to certain projects, obviously. So an EIA will be necessary to before conducting a large industrial construction, but it will not be necessary for a very minor construction project. So if you apply that to climate change, there would be a difficulty of deciding in what cases greenhouse gas emissions are significant enough to require the conduct of a climate assessment. The second difficulty is that a project's greenhouse gas emission is not going to have any direct impact on anyone in particular. It would only have a broad diffuse impact by adding a little bit of greenhouse gases in the atmosphere. So we won't really identify any affected population. There will be no one to notify or consult. At least there will be no one affected by the project that will have to be notified or consulted. And therefore, there are some questions as to whether the public participation component of an EIA could be implemented in relation to greenhouse gas emissions, or if it could be implemented in any meaningful and useful ways. And the third objection is whether climate assessment at the end of the day can be an effective tool for climate change mitigation. So I'm going to discuss each of those three concerns or objections relatively quickly, because I want to keep some time for the Q&A as well. And so spoiler alert, I don't think that any of those objections are well grounded, but they do show some important issues that need to be addressed more systematically than they have been so far in the practice of states. So the first objection, again, is the idea that any project taken individually contributes almost nothing to global greenhouse gas emissions, and therefore does not cause any measurable impact anywhere in the world. For instance, the New Zealand Court of Appeal said that a project's greenhouse gas emissions can only be an infinitesimal contribution to climate change. Jacqueline Peel called that issue the drop in the ocean issue. Any individual project contributes just one small drop in the large ocean of global greenhouse gas emissions. One coal plant in Hong Kong or in India would only contribute perhaps 1 in 1,000 of global greenhouse gas emissions for a very large coal plant. If you do not implement the coal plant project, there will be no measurable difference in terms of global greenhouse gas emissions. My response to the drop in the ocean problem is that it just all depends on the scale. The drop in the ocean could be a drop in a thimble if you look at it from a different perspective. You basically have to look at a more relevant benchmark. If you look at a coal plant implemented in Hong Kong in a global context, the greenhouse gas emissions from the coal plant will be infinitesimally small, it will be negligible. But if you look at the benefit of a coal plant in Hong Kong, globally, that will be very small as well. It will contribute almost nothing to global power generation. To understand the benefits and the cost of a project, you have to look at it in its context, at the right scale. So if you look at a coal plant, if you want to know whether the greenhouse gas emissions of the coal plant are significant, and therefore whether the coal plant has to go through a climate assessment, you have to look at local benchmarks. It might be that you will look at the emissions of greenhouse gases in the region in which the coal plant electricity will be used. So it might be if it's in Hong Kong, you will look at Hong Kong. If it's in China, you will look at the province probably. You may look at the emissions of similar projects, and that would be interesting to look at whether a new coal plant that we want to build in Hong Kong will emit the same amount of greenhouse gases or more or less than another existing coal plant. Whether the new coal plant will be relatively efficient in terms of power generation as compared to greenhouse gas emissions compared with similar projects. You could look also at local or national emissions reduction commitments. And that's something often done, for instance, in Canada, where the EIA will compare the emissions of the project with the objective of emission reduction applicable in the same local unit, the same province most of the time. In the case of the Hong Kong Airport extension, the Hong Kong Airport Authority conducted a study that showed that the extension of the airport will increase greenhouse gas emissions in Hong Kong under the most credible methodology by the equivalent of 2/3 of the emission reduction that Hong Kong wants to achieve by 2030. So 2/3 of the mitigation action implemented in Hong Kong will be cancelled out by a single project, which is not within the scope of those emission reduction. And we can also look at other tools, like in the US, at the federal and sometimes at the state level. One common unit is what the Council for Environmental Quality calls the social cost of carbon. This is basically a dollar price per ton of carbon, which is conceptually quite problematic. We don't know the cost of climate change. There are very different estimates of the value, but at least that's very easy. You just have to calculate the amount of greenhouse gas emissions that the project will generate, and then you have a dollar value that you can compare with the benefit, the economic benefits of the project. So you have different methods, and there is a need to compare to try to find out which method is more appropriate at what time. But I think the response to the objection is that there are some ways to look at whether a project causes significant amount of greenhouse gas emissions. You just have to look at it at scale. Then the second objection will be that we don't really know who to notify and consult, because nobody is specifically affected by the greenhouse gas emissions of a coal plant or an airport project. Those greenhouse gas emissions just add to the global amount and doesn't cause harm to anyone in particular. It's more a diffuse, cumulative kind of harm. There have been different responses in practice. One is very unique. It shouldn't be e.g., it should be i.e. It's the only example. It's not an example. It's the only instance. That's the case of the debate in Czech Republic about extending the time life, the operation of a coal plant in Poneřov in Czech Republic. The Czech Republic at the time, it was in the 1990s or 2000s, had a very extensive EIA statute that allowed anyone concerned by a project to intervene in the public participation phase of the EIA. So the project proponent went through the scientific study, then advertised the scientific study and called for anyone to intervene. And the state of Micronesia, a small island state in the Pacific Ocean, asked for the authorization to intervene. And that was the first time, and I think the only time until now, when a sovereign state intervened in a domestic EIA procedure in a foreign country. And this led to political consequences, a lot of embarrassment for Czech Republic. It came to the attention of many people who had never heard about the coal plant, that it was the single greatest greenhouse gas emission project in the entire Europe at the time. It's a very big and very inefficient coal plant from the Soviet time, which, if I remember well, contributed 0.5% of global greenhouse gas emissions. So a massive, very inefficient coal plant. And the Micronesia's intervention led the Czech government to interrupt the process of EIA and to decide not to extend the coal plant. So this had actually a big political impact. That's really beside the point. That's kind of a weird system where you will have one state intervening in a particular project. What Micronesia may want to say about the Poneřov project will not be different from what Micronesia would want to say about the airport project in Hong Kong. They will always say the same thing. They would say, we are affected by the impacts of climate change, and we want every state in the world to reduce their greenhouse gas emissions. This is not specific to the Poneřov project. And Micronesia will have a very hard time to explain how they are directly affected by the greenhouse gas emission from this particular project. So the entire thing here is a bit weird in the sense that you don't have a direct causal link between a project and a would-be affected state or affected population. And the comments that may come from those affected states or affected population will not be specific to the project. There is, however, a very narrow recognition of notification and consultation under customary international law. And so I think the objection is really based on people who read the Espoo Convention which has more demanding obligations on notification consultation. But under Customary International Law, the ICJ in 2015 said that notification consultation is only required when it is necessary to determine the appropriate measures to prevent or mitigate the risk. And most likely in the case of greenhouse gas emissions, it is not really necessary for a notification or consultation to take place, because the emitting country will have an idea about the impact of greenhouse gas emissions anyway. The functional equivalent of notification and consultation will be, I believe, some existing processes that take place under the UNFCCC or under the Paris Agreement. At the moment, every state is required to report on a regular basis, yearly or every 2 years, on their level of greenhouse gas emissions, their projections for their greenhouse gas emissions in the years to go, and the measures they are taking to reduce those greenhouse gas emissions. Those reports are then reviewed, and then there is a global stocktake that will take place under the Paris Agreement every 5 years, started in 2023, where Micronesia and any other state will have the opportunity to clarify their views. So I think this makes much more sense to have this unique global process instead of having a project-specific notification and consultation process. So to conclude on a notification consultation, I think this is a valid objection, but not one which is really relevant, because notification consultation are not necessary to a meaningful environmental impact assessment process. We have to understand that public participation in an EIA is not really about having affected stakeholders participate. A lot of EIA reports are about ecological impacts. For instance, the extension of the airport in Hong Kong affects marine life. We're not going to ask the dolphins to intervene and give us their views about the airport. Those who intervene are NGOs who speak about their understanding of the problems that the project may raise. They are not people affected by the project. They are people interested in the project. And even if you don't have a population directly affected by climate change, you still have interested stakeholders that will make their views known. And you still have the opportunity for a meaningful public consultation process, even if you don't have any directly affected population. Now, quickly on the third objection, is climate assessment effective? The short response is yes, but not always. And you will not expect EIA to work, to make a difference all the time. In many cases, it is just a painful administrative process that takes time and takes, requires a lot of patience from everyone. I mentioned before the case of the coal plant in South Africa, the decision of the High Court of South Africa in Earthlife Africa, Johannesburg. The project proponent basically had to apply for a new EIA approval. In a new EIA report, they documented the greenhouse gas emissions, and the project was approved without any modifications. So the only consequence of the, if you want to be very cynical, the only consequence of the High Court judgment was a waste of time and perhaps a gain of time for greenhouse gas emissions. It will postpone those emissions by a few years. But there's also perhaps a chilling effect on other proponents, project proponents, to think a bit more before proposing a project, try to think about ways to reduce emissions. There may be some diffuse implications or effects that may be quite difficult to measure in practice. There are some instances where climate assessment has led to the rejection of a project. And you may have heard a few months ago of the case of Gloucester Resources Limited in New South Wales in Australia, where the Land and Environmental Court, Judge Preston, decided to not to authorize a project of a coal mine on the ground of its greenhouse gas emissions. So that was a very specific procedure where basically the court was making the decision, as in most jurisdictions, only the administration can do. It's a merit review, it's not a judicial review. So usually this decision will be made by the government and will not be as well documented as when it is made by a court. But so there are some questions as to whether this is a very smart decision. Some people said, well, if you don't allow this coal mine, there will be another coal mine, perhaps in a different province or state in Australia, that will produce the same coal and lead to the same greenhouse gas emissions. There are some important questions to be asked, and one can be skeptical with regard to this decision. What I find most effective, however, is not prohibiting a project entirely. It is allowing the project, but making sure that the details of the project are designed in such a way as to reduce greenhouse gas emissions marginally. In Canada, for instance, there is some study of a number of EIA that shows that it became a common practice for different administrations in federal and level and the provinces to impose a best available technology requirement on any project that causes significant greenhouse gas emissions. So that could be, if you have a coal mine, well, you can still burn the coal, but try to avoid releasing methane during the mining operation. Small alteration of the project, which may decrease greenhouse gas emissions by 5, 10, perhaps 20%. An airport, it could be the design of the airport, it could be having the runway at a different location to reduce the taxiing distance. It could be having a system to connect the plane at the gate to the air conditioning system in the airport so that the airplane does not use its inefficient engine for air conditioning. Some small design alterations that may reduce greenhouse gas emissions, not prevent all greenhouse gas emissions, but reduce them in some meaningful ways. So climate assessment is not a silver bullet, but it does bring some incremental benefits in a respectable number of projects. Now, in terms of conclusion, what I have shown is that from an inductive approach, we don't have clear evidence of customary rule requiring states to conduct a climate assessment. From a deductive approach, we don't have any strong objection to the fact that EIA is an appropriate measure, but that's not necessarily proving that it is a necessary measure. So there's a bit more nuance in the paper than I could present in a short presentation, but it might be an appropriate measure. It is not necessarily a necessary measure, and as such, the deductive approach is not, in my view, just as solid, as strong as we need to demonstrate conclusively the existence of a customary rule. So the conclusion in the paper published a year ago and written 2 years ago is that there was an emerging obligation, but not yet a well-settled obligation to conduct climate assessment. And I think over time this will be, there will be a stronger evidence of an obligation. There is a clear trend in the practice of all states toward climate assessment in all jurisdictions. In the last 10 years, I'm not aware of any states going from requiring a climate assessment to not requiring it, but I'm aware of dozens of states going the other way. So there is a clear one-way trend towards recognizing climate assessment as an obligation. But there are many questions that remain open, and that's also why I wanted to speak about those objections. There are many questions about how to conduct a climate assessment, And those questions are discussed in every country, in many countries, in isolation. I mentioned New Zealand and Kazakhstan saying that they cannot have a climate assessment because they will have a cap and trade mechanism. At the same time, the EU, some states in the US, like California, had both. So if Kazakhstan and New Zealand had exchanged with the EU and California, they would have realized that their reasoning would at least need to be questioned by the practice and the experience of other jurisdictions. I think there is a need for much more comparative research on those questions, because there is at the moment very little cross-fertilization between national debates. And that's all. Thank you very much for your attention. And I really look forward for any questions. If you don't have enough time, you can also contact me by email at any point. Thank you.
Well, thank you so very much, Benoit, for this really interesting and also thought-provoking presentation. And also many thanks to those of you who already sent me your questions. Please continue to do so, because we still roughly have about 10 minutes. Benoit, please allow me to ask you, I mean, you need some time to rest, I think. Please drink some water if you can. Please allow me to ask you the first question, which is relevant to climate assessment. You give some examples of general practice by selected jurisdictions that have taken reducing greenhouse gas emissions in the process of EIA. And also you say that climate assessment does not always prevent projects with significant impact on climate change. So based on the cases you've looked at, have you seen any cases where climate assessment is the determining factor in the final outcome of the EIA?
I understood the question, I think, as whether there are any cases where climate assessment has led to actual consequences, right, for the project. I think the response is actually on the last slide. The case of Gloucester Resources Limited, the court said that the coal mine should not proceed because of the impact that all of the coal will have on the environment. So this is different from the case of Earth Life Africa Johannesburg before, where the court said that the EIA report was not complete, the information was not provided, therefore you have to try again. The case of Gloucester Resources Limited is one where everything was well documented, and the court, in that case, acting as a policy maker, as a decision maker. So the decision maker, if you will, said that the project should not be conducted because of the impact it will have on climate change. And that was really the only environmental impact that was at issue. That's the most drastic consequence. In most cases, the only consequence would be some conditions. The project will be approved, but at the condition that it is to be implemented with particular modalities. You should, if you have a coal mine, you should recover the methane. That's kind of a common requirement now. So when you mine some coal, you always have some methane escaping. Very often the methane is just vented in the atmosphere, and methane is a greenhouse gas, a very potent one. So instead of venting the methane, an increasingly common requirement is to recover the methane, or most of it, which is easier when the mine is underground, obviously, and then perhaps to burn it, which is better because then you have carbon dioxide, which is less potent than methane emissions.
Well, thank you. So the second question is related to the benchmark issue you mentioned in the EIA process. So given that the EIA mechanism has been dominantly established by national law, and there are obviously different procedural and also substantive requirements. So how do you ensure that the results from the EIA process could be consistently used in the mitigation of climate change?
Right, very good question. Let me just try. Yeah. So how do we know whether climate assessment will be implemented consistently? My understanding is that it is not implemented consistently at all, nor is environmental impact assessment. If you look at EIA law in Hong Kong, in mainland China, in the EU or in the US or anywhere else, it is totally different. You have some common features. You have scientific study and public participation. Those are the two elements. If you don't have one of them, it's not clear whether it is an EIA. But then everything else is different in every country for EIA and for climate assessment. You will have different scope of EIA legislation. So some projects in the EU will have to go through an EIA, but the same project in mainland China may or may not have to go through an EIA. So you may have different scope of regulation, and the same would apply for climate assessment. And then you have different benchmarks as well. Very often we will look in Hong Kong at the Hong Kong EIA ordinance. We will look at the local standards for air or water pollution. But there are jurisdictions that will look at other things as well. In the US, the trend is really to try to give a dollar value to everything. So they will not just look at whether the air pollution is making it difficult to comply with existing environmental standards. They will also look at whether it is disproportionate. So the short response is really there's no way to ensure consistency. I think what matters is that there is some sort of documentation that is relatively objective. It could be conducted in very different ways, but the information should be consistent within one jurisdiction. I think that's more important than consistent among jurisdictions. So in Canada, you have a number of EIAs looking at greenhouse gas emissions, and they look at them in the same way. So you can compare two projects submitted to the same decision maker, and you can ensure some fairness in decision making.
Well, thank you for clarifying, because I think we still have roughly about 3 minutes left, but I do have two questions here, which I think are also very important. Let me just ask them all together to you. So the first one is about the trend that you mentioned about incorporating climate assessment in the increasingly number of jurisdictions, which is obviously a very positive trend. So the question is about the major barriers, again, from your research and also observation. What are the major barriers to include climate assessment in the domestic EIA process? And also another question here, which I think is also relevant, is although your presentation focused entirely on mitigation, but what about adaptation? Because I mean, obviously EIA is quite an important part of the adaptation process as well.
Thank you. Two very interesting questions again. So the barriers to the diffusion of climate assessment. So I guess sometimes there will be just administrative inertia, and we are in Hong Kong. Some of us are in Hong Kong. I'm not going to point to Hong Kong in particular, but you know what I mean. 23 years and no modification at all in the EIA ordinance. I think this cannot be explained by anything else than just a lack of interest, a lack of concern for the environment, and perhaps other political priorities. But in other places, laws have been modified more frequently. I think India will also be an example of perhaps climate change not being the main concern in the implementation of EIA. So inertia would be one factor. Another one would be a lack of understanding. And Kazakhstan, New Zealand would be clear examples of that on the cap and trade objection. Which I believe is an invalid objection, is misunderstanding of the nature of cap and trade and or the nature of climate assessment, because one does not exclude the application or the usefulness of the other. So that also relates to the lack of a global comparative dialogue, the fact that Kazakhstan or New Zealand are not really learning from what other jurisdictions are doing successfully, or drawing lessons from what they're not doing successfully. I think that would be the main. There might be also some bad will, but I don't think that's the main concern really. In a rational, if you look at states as rational beings trying to take decisions in their own interest, you will expect that they will be reluctant to implement climate assessment because this is not benefiting to themselves. It is benefiting the world, but not themselves. But I'm not sure if that's really effective, because climate assessment is just a procedure. It is not binding the state to make any substantive decision at the end of the day. So they could always document greenhouse gas emissions and then still approve the project. So I think it's mostly inertia and a lack of understanding. On the second question, adaptation. So that's a really different question. Very often those two are, the two questions are addressed together, but I think they have to be distinguished. Many EIA laws in many places in the world include consideration for the potential impacts of climate change. And this is in the interest of the state or the jurisdiction to make sure that the airport project that you're building in Hong Kong will not be submerged by sea level rise in 50 years, because then you will have to rebuild it, and that's not really, we prefer to take that into account early on in the development project. The difference is then that adaptation is something in the state's own interest, whereas mitigation is more something that the state does in a common interest. So therefore, you would expect adaptation to be to develop more quickly in domestic EIA legislation than climate change mitigation. There could be some need to compare how adaptation is implemented in different EIA frameworks in different places, but I think that would be a very different research than the one I'm trying to conduct here, because the questions will be very different. So the three objections, for instance, I mentioned, only apply to climate change mitigation. So politically, mitigation and adaptation are very often brought together, sometimes in the same instrument. So the EU directives have been modified at the same time to include mitigation and adaptation. A number of laws include both mitigation and adaptation at the same time. But conceptually, I think we have to distinguish them because they are very different issues.
Well, thank you very much, Benoit, for answering those questions. I think we have gone slightly over time, but that's really inevitable. Thanks again, everybody, for joining us. Just before you go, I just really want to share with you the upcoming seminar, which is going to take place on the 4th of September. You can find those information on the CUHK Law website. Thank you once again, Benoit, for your excellent presentation. And then thanks to everyone. Please take care, and I hope to see you again soon online. I'll close the meeting now. Bye,
Thank you
everyone.
very much.